All right, welcome everyone. It's great to be here for day two. I'm David McCombs. I'm a partner with Haynes & Boone, and I'm also the co-chair for the Institute for Law and Technology at the Center for American and International. This has been a great program now. We're in our fourth year, and it's really what is great is it's a three-legged stool, which provides for a lot of extra stability. We've got Guildhall, SMU Guildhall, SMU Dedman School of Law, and the Center for American and International Law. And a lot of people work hard to put this program together. I'd just like to thank the staff for Guildhall, for SMU, and then at the center, I'd also like to, in particular, thank Mark Smith and Alan Dunlop for their efforts, and of course Ron Jenkins, who really is the mastermind behind a lot of this program. Yesterday's program was just excellent. In terms of what I can say about yesterday, what struck me is it's not just the download of the great information that we got, but it's just the incredible raw talent that we have in this industry, and it's talent plus passion. And what could you ask for in terms of a better recipe than that for the future? So we have a lot of great people, and we're going to have more of that today, and I'm going to turn it over to Xuan-Thao to kick off the program this morning.
Good morning. I'm so pleased to hold this pamphlet in my hands. Every year, when you return here, you get a copy of the review of cases of the previous year. This is the result of hard work of law students. And for this particular year, the 2011 review of cases, two of my best students, Ken Jordan and Robert Wilkinson, they put numerous hours to prepare this pamphlet. And I hope that you have a chance to have a copy and take it home. And also, there's some things about these students in general that nowadays, we are training students not only in intellectual property law, but they drafting contracts. They conduct due diligence for acquisition. And what does it mean to buy a technology company? And so they doing all that work. What I'm trying to tell you that hire them. And use them as your legal intern, because they are the 3L student. What is the best way? I remember that Ted Price talked about the X, Y, and the Z generation. The law student today is the Y generation. They grew up with the internet from the very early age, and they understand Facebook much better than most people. In fact, they update their Facebook page before they even study for their finals. And so you can see then that they are the ones that understand, that have a strong understanding of game law. With that, well, why we have such wonderful students? Because we have somebody like Professor Keith Robinson. Professor Keith Robinson will speak this morning on the review of 2011 games law. Professor Keith Robinson came to us from Duke University. He was an electrical engineer from Duke, and thereafter he went to work in the technology industry for several years, including the games industry. Thereafter, he returned to Duke and went to law school and earned his JDs there. Professor Keith Robinson then spent the next 6 years in Washington, D.C. at the law firm of Foley Garner. And what he did in Washington, D.C., he's the kind of patent attorney that listened to the inventors, listened to the innovators, and interviewed the clients in depth and figured out strategically how to patent innovations, how to exploit and monetize intellectual property. With that background, Professor Keith Robinson will give us a review of the cases today. Keith?
Okay, thank you, Professor Nguyen, for that great introduction. Good morning, everyone. I'm very happy and pleased to be a part of this program. It's something that I heard about before I was affiliated with SMU. I think it is a terrific program, and the information that is exchanged is very valuable. I also like, before I get started, I also like to thank one of my research assistants, Laura Hayes, for her help in helping me put together this presentation. Now, over the course of the past few months, I've spent a significant amount of time reviewing not only the court decisions that were released in 2011, but also the lawsuits that were filed in 2011. And there were a significant amount. And there's a significant amount of information that we can glean from both the litigation and the court decisions. And what I want to do today is provide you with the answer to 3 questions that this information suggests, okay? And the first question is, who or what can I safely depict in my games, okay? The second question is, what is the patenting landscape for games going forward in 2012? And thirdly, what are some of the preeminent legal challenges facing social gaming moving forward in 2012? So those are the 3 questions that I want to try and take a look at and answer for you today. Let's start with publicity rights, okay? There are 3 important cases that I want to talk about in publicity rights that were decided this year, having to do with sports, guns, and rock and roll, all right? The first case is Hart versus EA. All right, in this case, the plaintiff, Hart, was a football player for Rutgers University, a quarterback, I believe, and he brought suit against Electronic Arts for the depiction of his likeness in EA's NCAA football title. And what Hart argued was that in the NCAA football game, the quarterback that was depicted had all his attributes. He was the same height as Hart, he was the same weight as Hart, his eye color, his hair color was the same, his facial features were the same. Even the detail down to the accessories he wore on his uniform were similar. So the way he wore his wristband when he played football, that was the way he was depicted in the game. Now, in response to that, EA argued that their use of his likeness was protected under the First Amendment. EA said that while we do use his likeness initially, there are several features that we option that allow players to change how he looks. So the game gave players features where they could go in, start with Hart as a raw material, and then change his hair color, change his facial features, modify how he wore his uniform. And the court agreed with this argument. The court said that under the First Amendment, EA's use of Hart's likeness was protected. It was transformative use of Hart's image and was protected under the First Amendment. So EA succeeded in effectively defending its title in this case. The second case that I want to talk about has to do with the band No Doubt, okay? And this case has to do with No Doubt's participation in the game Band Hero, published by Activision. And in this game, Band Hero licensed the use of No Doubt's image and its songs to be used in the game. No Doubt even agreed to come in, and they wore those funny image capture suits so that they could be depicted accurately in the game. However, once the game was complete, No Doubt discovered a feature that Band Hero included in the game that would allow a player to unlock the band members. And what this did was it allowed a player to use the band members to sing different songs that No Doubt doesn't sing, and it also allowed the player to break up the band and use the players individually. No Doubt brought suit claiming that this was outside the scope of the licensing agreement. So in this case, again, Activision, in response, relied on the First Amendment. Activision argued that, look, our use of the band No Doubt in this game is protected under the First Amendment. However, in this case, the court did not side with the First Amendment argument that Activision made. And the reason was the court looked at the fact that In the game, there was no way to transform any of the images of the No Doubt band members. So you couldn't change any of their attributes. All you got was, when you picked Gwen Stefani, you got Gwen Stefani. There was no way to change her hair color, the outfit she had on, any of those things. And the court ruled that that was not transformative use, which was protected under the First Amendment. Finally, let's talk about guns. So in the Dillinger v. EA case, the estate of the famous American gangster John Dillinger brought suit against EA for the use of his name Dillinger in association with a Tommy gun that was used in EA's Godfather games. Okay? And what the John Dillinger estate argued was that that was an unauthorized use of the Dillinger name. In response, EA again argued that its use of Dillinger was protected under the First Amendment. In analyzing this case, the court looked at a test under the First Amendment called the Rogers test, okay? And the court said that, well, there is a relationship between the name Dillinger, a Tommy gun, and a gangster depiction such as The Godfather. There is a relationship there. However, the court held that a consumer is not going to be misled or confused by the name Dillinger and think that Dillinger is authorizing or sponsoring the game Godfather. And so, again, EA succeeded in this case under the First Amendment. Now, briefly, let's turn to the patent landscape. So in the gaming world, you have what's called a NPC, a non-player character. They're friendly guys that you find throughout MMOs. They give you things to do, tasks, and they give you gold in return, okay? In the patenting realm, we have what's called NPEs. They're non-practicing entities, all right? Now, the non-practicing entity, the business model is to collect and license their technology to others. The reason why we call them non-practicing entities is that generally they do not make or use any of the technology that they own patents on. There's nothing legally wrong with this, and there are some good non-practicing entities out there. Two of the more famous non-practicing entities were very active in 2011, Walker Digital and Lodsys. So Walker Digital sued over 100 companies for patent infringement, and one of its premier patents included in its patent portfolio is a patent for online game tournaments. So as you can imagine, there are a number of game creators that were sued alleging infringement of that patent. That litigation is ongoing, and we're watching that closely in 2012 to see where it goes. In addition, there is a NPE called Lodsys. Now, what's interesting about the Lodsys patents is that they recently sued mobile game developers that publish their games in the App Store. And Apple got involved. And the way Apple got involved is because Apple actually licensed some of the patents that Lodsys is asserting against its developers. And Apple said to Lodsys, look, you can't sue our developers that are making these games and selling them in the App Store. Now, as it stands right now, the litigation is ongoing. It's unclear whether or not the relationship Apple has with Lodsys is going to have any legal effect on the lawsuits between Lodsys and these app developers. Again, something to watch very closely. Now, there is a silver lining regarding NPEs, and that's the recent America Invents Act that was passed last year. And there is a provision in the American Invents Act that commentators believe will limit the ability of NPEs to sue several defendants at once. So what we think is going to happen and what we think we're going to see is instead we're going to see targeted litigation against select entities instead of this wholesale litigation where you sue about 100 defendants and drag them all into court. All right, finally, let's look at the social gaming realm. The Learning Company got into a dispute this year with Zynga, of course, over the game Oregon Trail, all right? In the lawsuit states, or in the complaint, Oregon Trail was owned by the Learning Company, and they approached Zynga about doing a Facebook version of the game. They shared with them plans about the game, their marketing materials for the game, and somewhere along the way, conversation and the discussion broke off. A few months later, Zynga offered an extension for its Frontierville game, which it called Frontierville's Oregon Trail, okay? The Learning Company promptly sued Zynga for trademark infringement. This lawsuit is also pending and ongoing and something we're watching carefully. The last time I checked Zynga's game offerings, Frontierville's Oregon Trail has now morphed into the Pioneer Trail, okay? So that's what they're calling it now. And then finally, I think there was a little bit of discussion about this yesterday. Social Apps also sued Zynga for allegedly stealing its Farmville game from Social Apps. And in this case, Social Apps entered into discussions with Zynga. Zynga was thinking about acquiring Social Apps because they had a Facebook game called My Farm. Through the course of discussions, Social Apps actually shared source code with Zynga, source code from the My Farm game with Zynga. Soon thereafter, that source code was shared under a confidentiality agreement. Zynga came out with the My Farm game. I'm sorry, the Farmville game. And so again, this litigation is ongoing. It's something that we continue to watch, but we think it might have big implications here. So, in answer to those three questions I proposed at the beginning of my presentation, copying or cloning games in the social space is going to continue to be a major challenge for social games, all right? I think as recently as yesterday, there was an article on Game Sutra about a small iPhone developer that had the iPhone Game of the Year, who are now asserting that Zynga has stolen its game and created a Facebook version of the game. So this is happening as we speak. Also, it's a major challenge from a legal standpoint because I think that attorneys are going to have to get very creative about how they counsel their clients as to how they can protect their IP in this space. Second, NPEs continue to exist. They're going to continue to acquire numerous patents. However, because of the Patent Reform Act, they're going to become more selective about their targets. Okay, so NPEs will continue to selectively target game creators, the creators of game peripherals used in games for patent infringement. And then finally, as to the question of who or what I can depict in my game, the jury is still out on that one, okay? So there's a case in another district called Keller v. EA, which is another lawsuit involving NCAA football, another lawsuit brought by a plaintiff who is a football player, alleging that EA misappropriated his likeness in the game. And in that case, at the district court level, the district court held that EA was not protected under the First Amendment, and its use of the player's likeness in the game was not transformative and protected under the First Amendment. Now, this case was appealed, and the appeal was heard this year. We're still waiting on a decision in that case. Also, earlier this year, EA instituted a lawsuit against an aircraft manufacturer in response to the aircraft manufacturer alleged threats to sue EA for use of one of its aircraft or depiction of one of its aircraft in the Battlefield 3 game. So that lawsuit just started, I think it was just filed in January of this year. So that's also a lawsuit to continue to keep an eye on and watch. So the question as to whether what you can depict from the real world in your games is still a little bit unsettled. However, a lot of commentators think that in view of the Brown v. Entertainment Merchants Association case, which we're going to hear about in a minute, that the video game creators and the video game developers have been strengthened by that case because the thought is that it now gives video games full protection under the First Amendment, and it will strengthen its defenses under the First Amendment. I'll be around all day. I love to talk about these issues with you further if you have any questions. My contact information is up there if you don't get a chance to talk with me today. Thank you very much for your attention, and I hope you enjoy the rest of the conference.
So our next speaker is Christian Genetski, and he is joining us today from Washington, D.C. I was asking Christian when he became the Senior VP and General Counsel of the Entertainment Software Association, and it just so happens that that was very recently, just last summer. And prior to becoming the GC for the ESA, Christian had his own law firm, Zwillinger Genetski, LLP. He was also, prior to that, a partner with Sonnenschein, and there he defended many different gaming companies in connection with government regulation and third-party infringement matters. He's also served as a federal prosecutor in the Computer Crime and Intellectual Property section of the Justice Department. He's been the head vice chair of Sonnenschein's Internet Data Protection and Communications Practice Group, a clear expert in this field. Please welcome Christian.
Thank you. Give me a moment to, not going to be much good without the presentation yet. Kind of ruin my bona fides if I couldn't get the PowerPoint hooked up. So I'm very pleased to be here this morning with you. This is my second time to attend this conference, and I think it's fantastic. And it's an incredible program that SM is here, and so it's a real pleasure to be with you. And I was here 2 years ago. I spoke on a panel. I was in private practice and embroiled in representing Blizzard Entertainment in a lawsuit against MDY Industries, and now I'm in a very sort of related but different position here on behalf of the ESA. As David mentioned, I joined the association in early July of 2011, conveniently timing my arrival 2 weeks after the Supreme Court issued its decision in Brown. I had made a very strong bet on a good outcome by accepting the job before the decision was handed down. I was confident that the Supreme Court would do the right thing, but I'm able, because of that timing, to speak glowingly about what an incredible job the ESA did in marshaling the resources that generated that outcome, because my predecessor, Ken Doroshow, and the other members of the ESA team who I work with now are the ones that get the credit, along with the leaders, of course, of our industry who supported that effort. So I'm going to talk broadly about two categories today. I mean, the first will be about the Brown case. To use an analogy that may be a sore subject to the Dallas natives, given what's going on with the New York Giants, Brown was effectively the video game industry's Super Bowl victory against content regulation after a string of lower court victories that would have been sort of the equivalent of the leading up to the Super Bowl playoff run. I'll talk about the case itself, what the 4 different opinions said, what the implications of the majority opinion are for our industry, both in the content regulation area and beyond. And then I'll spend the second half of my talk, depending on sort of time permitting, on where we go from here and the path forward. And I think you'll see a lot of what I talk about for the legal and policy challenges for the video game industry, very reflective of what much of the discussion yesterday that I was able to be here for and listen to, particularly in the morning sessions about the areas in which our industry is evolving and the different sorts of challenges that presents. For those of you that aren't familiar with the ESA, here is the advertisement slide to start with. We are the U.S. Trade Association for the video game industry, representing most of the all the major console manufacturers, most of the major game publishers. We have a business and consumer affairs and outreach department, a very robust government affairs team on both the federal and state level, and the legal and policy team, which I manage, which includes an anti-piracy program and does a lot of work in intellectual property policy and increasingly, as I'll talk about in the second half of my presentation, broader technology policy. And it certainly, last bullet but not least, we were responsible for putting on the E3 trade show, which is a great event every year. I don't know why I'm getting that little button. That's not good. Oh, hold on. Yep, got it. All right, should be good. So I want to, before I get to the legalese, just a couple of prefatory slides with some statistics about the industry, about who gamers are, about what the industry is doing. And I do this when I speak about our industry. I mean, here we're sort of assembled with the choir, so these statistics are not nearly as surprising in a forum like this, but they're important, I think, because I think they inform and reflect what the Supreme Court decision means for where our industry is today and where it's going, and they also inform and reflect the challenges that we face in the future. I often ask people to close their eyes and conjure up a gamer in their mind, and I think still today most people get an image that is fairly similar to one another. When they do that, that person still very much exists. Some of us in this room probably are that person in one respect, or wish we still were to some degree. But if you look, most people don't, first of all, don't picture women when they do that. They typically don't picture someone over 50 years of age, but this is the shift. Gamer encompasses a much broader section of the populace than what most people have thought of historically. And we all sort of have personal anecdotes that hits this home. Mine, I was thinking about this morning. Over the holidays, my parents stayed with me in D.C., and I had something happen that had never happened to me before, which was I was sitting having a conversation with my mother, and for the first time, she was the one who kind of looked up and said, "Huh?" and was not paying attention to whatever it was I was rambling about. That typically is an interaction that's gone the other way. And the reason she didn't hear what I said was because she was staring down at her iPhone, trying to lock in a double word score in Words with Friends with one of her friends back in Birmingham, Alabama. When your mom doesn't have time for you because she's locked into mobile gaming, you know that there's truth. It's a very tangible evidence of these statistics. For those who are students here looking to get into this industry, this is a promising slide. This is a strong industry. It's an evolving industry. I'm not going to read the numbers to you, but it's an exciting time to be in this field, a dynamic time to be in this field. And the notion of what games are or what games can achieve is also evolving and changing. Games will always provide fun and entertainment. They are increasingly providing a foundation through which people connect to one another or reestablish long-lost connections with old friends. But they're also being used in a variety of really interesting ways for education, for medical research, using the same engagement that games provide and the problem-solving skills that are inherent in sort of game architecture. There's some really exciting things going on. And I think that the cumulative effect of those slides is that the industry is growing up, for lack of a better word, or has grown up. And we are now on a more equivalent footing with sort of sister expressive art forms. And that is nowhere better reflected than in the decision in the Brown case, which I'm going to talk about next. So when I, as general counsel of the Trade Industry Association, look out and see what are the legal challenges that we face that we have to be ready to meet, when you kind of take a look back and a look forward, there are sort of two categories. There are one, the challenges that have been over the last decade fairly unique and targeted at video game industry, and that's primarily been in the form of content regulation. Attempts federally that never gained full traction, but at the state level certainly did to legislate and regulate consumer choice about the video games that they're able to see, mostly aimed at minors and violent content. And then there are the legal challenges that our industry share with other industries. In the IP area, the video game industry obviously creates some of the most dynamic and incredible content, engaging content that we have, and it's important that creation be protectable. There we have we're there with all the other content creators. But increasingly, as we heard yesterday, when you're talking about some of the new gaming platforms, I think Richard said yesterday, you have to think about it as a business first and a game second. And there, our video game industry is now very much standing alongside with the social networking businesses and other Web 2.0, Web 3.0 sort of companies dealing with issues like privacy, data security, digital entitlements, those sorts of things. So content regulation. My trade association was formed 15 years ago in response to efforts aimed squarely at the video game industry and the evils, the so-called evils of violent video game content. And there's been a series of laws over since that time aimed with slightly different approaches, but all at the same ends, which was to regulate the distribution and sale of video games based on their content. And our industry has been united in the battle against those and asserting full and equivalent First Amendment protection. The track record has been very good. Leading up to the Brown case, 13-0, the industry has been in fighting back challenges, seeking injunctions. None of these laws took effect. They were all defeated in courts. What's interesting about that is when California petitioned to the Supreme Court for review of the decision in what was then called the Schwarzenegger case, typically, the Supreme Court grants a very, very low percentage of the number of petitions that are brought to its doors. And typically, the reason it grants a petition is because there's a split in authority amongst the various circuits, and the Supreme Court feels the need to step in and clarify who's right, effectively. 13-0, the last time I checked my math, is not much of a split. So I think that, if you speak to the lawyers at Jenner and Block, lawyers are very conservative. We heard a lot yesterday. It's easier for a lawyer to tell you no. Lawyers are pretty conservative about expectations management. But I think if they were being candid, they would have said it very, very long shot that this would have ever been heard by the Supreme Court. So when the court opted to hear it, that was a very serious day for our industry, because an adverse decision by the Supreme Court would put us in a very, very different place than where we are today. What did California's law do? It was typical in sort of the objectives it aimed to achieve, which was regulating violent video game content and the sale to minors. It specifically prohibited the sale or rental of any game that met its definition of violent video games and required a label of 18 to be placed on the package. You can see there the sort of the litany of activities in a game that would have qualified it as a violent video game. And the language at the end of the second bullet, that the game would have to lack serious literary, artistic, political, or scientific value for minors is that is borrowed language. That's not accidental language. It's borrowed from a New York law on obscenity that was upheld by the Supreme Court in the Ginsburg case. And so California was attempting to port over a standard that had survived First Amendment scrutiny in the obscenity context, crafting a specific law that protected children from obscenity that adults were not protected from. And so this law was a little bit unique in that respect. The arguments presented to the court, again, building on what I just said, California argued that the Ginsburg holding on obscenity should be expanded to children exposed to violence, specifically in the video game context. They asked that the court not apply strict scrutiny, but instead treat content-based regulations for speech directed at violent speech directed at children as a lesser protected category of speech. ESA, on the other hand, argued that that was the wrong starting point. The starting point for First Amendment analysis is whether or not the content subject to restriction is an expressive work that is entitled to full First Amendment protection. If so, then any content-based restriction is subject to strict scrutiny review. That's critical. In First Amendment law, the test yields the result in many cases. If strict scrutiny is applied, almost without exception, the law fails to pass constitutional muster. There has to be a compelling interest, and then the interest has to be achieved in a narrowly tailored manner. That's the two-part test, and it's generally well understood that it's the death knell for a law if it's subjected to strict scrutiny. That's why California was fighting on the ground of the threshold test. ESA also argued in the alternative that even if the court did not apply strict scrutiny and applied a lower balancing test, that really was irrelevant because the statute that California had drafted was unconstitutionally vague. If you go back to the definition of which games would fall under California's definition and decide which games required an 18 sticker and which didn't, the lines were far from clear, and a lot of that came out actually during California's oral argument before the court. Scalia really sort of took them to task about not being able to even answer and say you would have to develop organically over time, which games would be subject. Again, easy for me to speak to the incredible effort that was marshaled when granted review to represent our industry in this case. You can see the numbers there, 90 different organizations, and it was a broad spectrum of different organizations, a lot of groups that are often on opposing sides on other issues, uniting behind us on this. Incredibly, 10 attorneys general drafted and signed an amicus brief in support of our industry's position that this statute was unconstitutional. Many attorneys general were in other states were those leading the charge on these issues. Obviously, California's at the time, and so that was really an amazing effort to get that sort of recognition. And then, equally importantly, a long list of social scientists and researchers who proffered evidence to combat that California had put forth in support of its justification for the law that there were negative impacts to children from their exposure to violent video games, showing that the science in most of those studies was subject to a number of flaws and or was equally applicable well outside the video game context. We won. I think most of you know that. I will have a little bit in 4 or 5 slides, a little bit of breaking news, so a little teaser or spoiler alert there, although anybody who's checking a mobile device may already know what I'm alluding to. But as for the result of the case, we pictured there are 5 of my favorite justices. Not many people would probably put together that lineup of justices and claim to love them all passionately, but I do. Justice Scalia wrote the majority opinion for the court, 7-2 decision. 7 justices out of 9 voted to strike down the law. Justice Scalia wrote the opinion for the majority of 5. There were 2 concurring opinions, 2 dissents, which I'll talk about. And Justice Scalia applied the strict scrutiny test and struck down the law on that basis, finding that it neither had a compelling justification nor was it narrowly tailored. On the compelling justification, he pointed to the discrepancies in the social science and that it fell far short of what it would have required for California to prove. And on the tailoring, Scalia found that the law would have, if put into effect, would have actually been both under-inclusive and over-inclusive. What that means is under-inclusive because what the science suggested was, to the extent there was any effect, and there was dubious as to what extent there was any effect from violent video games, it measured out in those same studies as roughly equivalent to the effect of Saturday morning cartoons, movies, television, and many, many other forms of entertainment that all were clearly fully protected under the First Amendment, and which this law did not target. That if California was going after the justification it was proffering, it was taking only a sliver of all the things that its social science suggested should be treated similarly, which made clear in Scalia's mind and the majority of the court's mind that this was not about the effects. This was about what the exact thing the First Amendment prohibits, which is targeting the particular content, message, or viewpoint of a specific category of speech. He also said it was over-inclusive in that, and this is something at ESA we're very proud of because we are affiliated with the ESRB, the Voluntary Industry Ratings Organization. He said that the job that California asserts needs to be done by this law is effectively already being accomplished, that there's an existing voluntary industry self-regulation effort that achieves, that does a study show achieves these ends, and that beyond that, this law would have required the consent of all parents, and that the evidence suggested there were many parents who did not want to prohibit their children from being able to purchase these games, and then in that way the law was over-inclusive in that it placed restrictions on those who didn't want them. The most critical statements in the opinion, and the ones that are going to have a living, breathing, forward-looking effect for the industry and that tie to sort of the arrival of the full maturity of the video game industry, were those Scalia made at the outset of his opinion, where he found that strict scrutiny would apply. And you see one of our favorite quotes there, and basically what he's saying is video games are expressive works. They are art in the same way that film is, that literature, the greatest literature, there are great comparisons in the opinion, of Dante's Inferno to video games. And specifically, Scalia said one of the key arguments proffered by California, that the interactivity of video games, that somehow made video games different and less entitled to protection, that was actually backwards, that the greatest of all literature always has an interactive component, and that choose-your-own-adventure books are interactive, and that the interactivity of video games actually made it more expressive and more artistic, not less. These are linchpin findings by the court that will serve our industry well, and Scalia, rightly noted, and Jenner and Block did a great job in their argument of sort of pointing out that over history, as new art forms emerged, the same criticisms have been levied at them over time. Pulp magazines faced this. Movies obviously had their time being subjected to these sorts of regulations, and it had been the video games industry's turn, for lack of a better word, and that the same result was compelled for video games that each of those previous content regulation attempts had met. So Scalia, he looked at California's arguments, the majority opinion said this is not obscenity, which is something that's a traditional carve-out. There are very finite carve-outs from First Amendment protection for speech that is entitled to less protection. Obscenity is one, fighting words another. And what New York had done was carve out a protected area a less protected area of speech, and then distinguish between that speech directed at children versus adults. And that here, Violence in expressive works is something that we have always, as a nation, we've always protected. We've always considered that the highest in the group of protected expression, and it should be no different here. There were two justices who concurred in an opinion written by Justice Alito. They would have bypassed deciding whether strict scrutiny applied or not, and because they felt the law was easily struck down on the vagueness grounds, the sort of secondary argument that ESA raised. They said some things in that are mildly troubling, and you could have seen we would have been in a much different place had this been the majority opinion. Justice Alito pointed both to the fact that this is, he thought of this as a new and emerging space, a newer technology, sort of a different viewpoint on where video games were in the evolution, and that it might be premature to make judgments. Spent a lot of time talking about the interactivity and then sort of a litany of what he alleged were the most egregious examples and or sort of offensive subject matter found in video games as a reason for caution, even though they agreed that the California law didn't provide any sort of meaningful solution. Scalia sort of spoke to these concerns in the majority specifically and said that the very examples that Alito raises about certain subject matter that he found offensive and that many might find offensive in the games was the very reason that the First Amendment protection was so critical, because what the First Amendment does at its core is protect against discrimination against viewpoints and certain types of speech. There were two dissenters, each writing their own opinion, sort of wildly different points of view on why they would have upheld the law. Justice Thomas' dissent was based solely on his view that, taking sort of an originalist view, which he's known for, that at the time of the founders he did not find evidence that their First Amendment protection was intended to be afforded to children. He said that minors lack expressive rights except those granted to them by their parents. Now that's a popular point of view, I'm sure, in many households with unruly teenagers, but as against government regulation, it's not a widely accepted view. Justice Breyer dissented on other grounds. He actually would have applied strict scrutiny and found that the law would have withstood strict scrutiny, which again, as I said, is a very interesting position given Supreme Court precedent about how strict scrutiny typically comes out. As support for that view, he pointed to a lot of social science, that frankly, much of it from his own independent research, with lots of citations to web sources and things, even many materials outside the record of the case, which was sort of odd and something you have a little bit more freedom to do in a dissent. For the ESA, one of the most gratifying parts of the opinion was the recognition I alluded to earlier by Justice Scalia of the fact that industry on its own was largely achieving the objectives that California put forth as the justification for the law. And we remain committed to doing so going forward. I mean, the victory in the Supreme Court is critical and important, and a disincentive, a very strong disincentive to states to go on one of these, to introduce a similar law, because the fate of such a law is pretty clear at this point. But our industry remains committed to providing information and that parents need to evaluate the choices that they think are right for their children, and we think the ESRB does a good job of this. The FTC has repeatedly recognized the video game industry as doing it best amongst the various voluntary self-regulation efforts. The FTC has, again, consistently recognized our industry as the best. So here's the sort of the breaking news portion of our broadcast, and part of the reason I wasn't able to attend some of the sessions yesterday afternoon. In terms of lessons from the Supreme Court case, it's announced this morning, the press release has probably gone out by now, that we've reached an agreement on our attorney's fees petition with the state of California, under which they've agreed to reimburse ESA $950,000 for our attorney's fees incurred in connection with the Supreme Court case. When you total that up with what we'd already been awarded for the successes on the same, in connection with this same law, at the two lower courts, you're talking over $1.3 million price tag for this effort by California. And when you go back to the slide on the full set of 13 cases, you're talking about states coming out of pocket over $3 million in pursuit of these efforts. And I think that the bottom line from that going forward is clear that these efforts don't pay. And with the Supreme Court having spoken, we're optimistic that this is an issue that is settled. So what are the benefits and the implications of the case going forward? Clearly the statements, the clear definitive statements from the court that video games are on equal footing with other expressive content. Certainly, we hope spells the end of content regulation. But beyond that, it'll have other effects. And we heard this morning about a couple of cases, right of publicity cases involving EA, involving the same game in different courts in different parts of the country that had different outcomes. And one of the interesting things is that the timing of those cases is such that the Keller case was decided by the district court before the Brown opinion came out. The Hart case was decided after. And the Hart case relied heavily on Justice Scalia's opinion in Brown and the recognition of video games as an equal expressive art form in reaching its decision. So you start to see the broader effects. I think we'll see it in as interesting places, marketing and advertising, and attempts to regulate in-game advertising in a way that might be different than advertising, than product placement in television or in film. And I think the language of this opinion and the definitive holding will continue to have benefits in those areas as well. So our work is not done as an industry, and I think the legal challenges that we face are evolving sort of in lockstep with the way the industry delivers its content, offers its content, the experiences we offer users. And as I alluded to at the outset, there's trying to roughly put these in a couple buckets. I think there are intellectual property issues, and then there are the broader technology or e-commerce issues that our industry is going to be looking at. And you see here sort of the overview. I'll touch on a number of these briefly, and I hope will underscore that that we're going to be having a lot of different fights on a lot of different fronts, and some of them will affect all of the industry. Others will affect different parts of the industry, depending on whether you are a pure mobile app developer or whether you're a console manufacturer. You're going to face some different issues. The days of having the one issue where video games are in the crosshairs with content regulation, where everyone is on the same page and united, are changing. So on the intellectual property front, piracy of video game content remains a real problem. I mean, we have people attending this conference who are expending incredible resources and devoting incredible talent to developing amazing games. With just every year, the bar gets set higher. With the type of content that we get exposed to, and there are many here who are aspiring to be in this industry and to do the same thing. And it's important that those efforts and the incredible investment to create this content is able to be protected. It's at risk from a number of different sources. I mean, the challenges in this area change. The underlying fundamentals that it's that if there's theft of intellectual property, it's a problem for our industry, remain. How that occurs and happens continues to evolve. There's been a lot in the news in the past week about Mega Upload, a hosting site, and that was indicted by DOJ, and some follow-on activity there. There are, in the video game context specifically, The pirated games typically are able to be played because there are also modification services and technologies that allow circumvention of console security systems that would otherwise prohibit the play of pirated games on those devices. For MMOs and server-based games, unauthorized private servers pose a potential threat to subscription revenue streams. And in the online and mobile and browser-based market, I think that the problems tend to take on, they're somewhat IP problems, but also hacks, cheats, online fraud. These are the kinds of issues that those companies are facing as attacks on their business model. There are a number of ways to address these problems. We're working in all of these areas. I mean, certainly legislative and regulatory. There is the Copyright Office's triennial rulemaking is underway now to explore whether or not to grant exemptions to the DMCA's 1201 anti-circumvention provisions. There is a request in now that we'll be responding to in early February that would create an exemption that would allow for the jailbreaking of video game consoles. It's an important issue for our industry because, again, for whatever of the perhaps multitude of reasons why someone might want to circumvent the security on a game console, that same circumvention is what enables the play of pirated games, and that's obviously a problem for both the console makers and for our game publishers. Rogue sites legislation on the Hill has obviously gotten a lot of attention in the last month. It's sort of to be continued and to see where that goes, although I think there's underlying fundamental agreement that for the worst of the worst, this is a real problem and that we ought to think carefully, but think about trying to find meaningful solutions. We've already covered some of the case law there, in some of the right of publicity and other areas, but there are other cases, and I think there will continue to be sorting out issues that are going to have a big impact on our industry, both in the casual social gaming world. How do the IP laws weigh in on that? What does that mean? What's protectable? What sort of copying of ideas versus expression versus use of trademarks? How do we figure out those questions under the new models? There was an interesting and mostly unnoticed Ninth Circuit opinion in a case that I handled when I was in private practice that finished without me, involving Square Enix in the Ninth Circuit, where it was a class action lawsuit based on the loss, number of allegations, but at heart the loss of in-game characters. If playing an MMO, stopping playing for 3-4 years, coming back to the game and not being able to reclaim the characters that you played before you stopped playing the game, and whether or not there was some duty on behalf of the game publisher to maintain that data. And the Ninth Circuit, in a fairly summary opinion, pointed to the user agreement there and said it was disclosed up front that the characters didn't belong, that they wouldn't be maintained. It was clear, and the court upheld that and affirmed a motion to dismiss. There was some discussion in the morning panel yesterday. I think we will see this issue evolve, and I think the outcomes may depend heavily, of course, on what the upfront agreements say. But I think Richard made a very interesting point too, that the game design and game function will influence those legal issues as well. If you have degrading virtual assets, that's going to speak very directly to sort of consumer expectation. Obviously, also what you say to them in a clearly worded player agreement at the outset will too. On the IP front, there are also perhaps more quietly voluntary and cooperative efforts underway to try to speak to the underlying problems, both in education and in technology solutions. The copyright alert system was announced last year. It's something the film and music industries are embarked on with 6 of the major ISPs in the U.S., aimed at a education plus graduated notice response program for peer-to-peer infringements. Payment processors continue to work with content creators to try to make clear that their services aren't supporting sort of the worst of the worst infringements. And search providers and others are working on technologies to implement on a broader scale quicker and more effective takedowns, again, of sort of the egregious infringements. And then, as the mega upload case shows, that there's still a role for law enforcement here too, and some follow-on effects of what those law enforcement actions will lead to. Outside of the IP front, I mean, this is a slide with, the glorious crests of a number of different federal regulatory agencies, some cases for different types of movements, both domestically and internationally. And these represent issues that the ESA and our industry are working on now or have worked on in the last year. None of these probably are areas where we would have thought about being involved in 5 years ago. So this is where we're headed. These are the issues that our industry faces as we become more and more an online, social, connected sort of business. Probably at the top of that list, and there was some good discussion about this yesterday, are privacy interests. There is a ongoing debate, and it's taking place both in the United States and Canada and across the pond in the EU about what the right way forward is for balancing consumer privacy interests with the massive amounts of online data collection and sharing and disclosure. How do we balance that in a way that does not stifle technology innovation and curtail the ways that we can create great experiences for consumers? And there are very different approaches between the way things are moving in the U.S. and the way things are moving in the EU. There's more of I saw a presentation, which when I say these words will not surprise you, from a couple of esteemed law professors who said, we really have a reductionist approach in the U.S. to privacy and trying to define exactly the types of information that are subject to heightened protection, whereas in Europe they have a very expansionist view, in which sort of by default, if you pass the information to someone, even if it was the IP address that your computer passed, we're going to assume that if that's tied to you in any way, that's personal, and then we'll walk it back from that. So two very different approaches with very different implications. Here in the U.S., the Federal Trade Commission is really the primary driver, both through enforcement actions, a couple of high-profile consent decrees with Google and Facebook in the past 6 months. We the ESA, along with many in the tech industry, filed comments in the FTC's pending proposed COPPA rulemaking proceeding. COPPA is the Children's Online Privacy Protection Act, and it requires, basically requires that you have to get a parent's verifiable offline consent before you can collect or disclose certain personal information about children. It's passed in 2000 or 2001. It has historically only applied to real identity information, first name, last name, physical address, email address, identifiers that are uniquely and overtly tied to a specific individual. One of the things the FTC has proposed in its rulemaking is extending the definition of personal information to include some interesting things like persistent identifiers, which would be IP addresses, and critical to the video game industry, screen names. And screen names are obviously probably as more prevalently used in the video game industry than anywhere, and they're used largely, particularly in sort of freemium type offerings, to allow a user to have an interactive experience, to have their name show up on leaderboards, to be able to resume their progress in their game, to track experience points, all of these things in a pro-privacy way, in a way without having to collect real name and address information. And so we've filed comments there pointing out that there needs to be some careful thought given to balancing the ability to provide robust offerings to children, and outside of the COPPA context to adults, because in the behavioral advertising area, this same debate's playing out. Friction is a very important concept for games that are offered for free, that are ad-supported, or that rely on microtransactions. You need sustained user engagement. We heard some of the statistics yesterday about 90 seconds at a time, but it's the amount of times you come back to the game in the day. If you're playing in short bursts, you need to be able to get back to where you left off, and there has to be some sort of identifier to allow you to do that. And I think if we're, being honest about something like a COPPA restriction, which requires offline consent, that's a friction-inducing event that will cause drop-off in the game. And what that will lead to as a business reality, I think, is that you'll see fewer offerings made available to children. It won't eliminate them. There's a specific market, and there are publishers that are in that market, and if they need to collect what's now a broader definition of personal information, I think they'll still do that. But in many cases, I think what you'll see is, because of the friction it would induce, it really reduces the incentive. The friction will increase, it will reduce the incentive to make that offering available. And just the screen name and that sort of identifier will just be removed from the game, or the game just won't be offered. It'll be age gated and not available to children, and we think there are some downsides to that. And so we've spoken to that in our comments, and we're certainly not the only industry making these same points. More broadly, the FTC has an updated privacy report coming, which will speak much more broadly than children, their views going forward on privacy. I think you can see elements of it in the Google and Facebook settlements, but I had heard they were saying coming months for quite some time. I heard a few weeks ago I heard it phrased as the coming weeks the report would be out. I'm now told it's any day now, so that will be instructive and watched closely. There's a lot of action on Capitol Hill too. A number of bills and do not track bills that would require the upfront ability to opt out of any tracking of information, even beyond personal information. More broad privacy bills. There are child-focused bills. I think the general sentiment from our government affairs people is there will be a lot of activity in 2012, a lot of discussion about these bills, but given it's an election year and there's still sort of a lack of consensus, that it's probably unlikely that we'll see anything emerge and pass this year. Data security, obviously, it was a high-profile year for the video game industry, along with a host of other victims in the data security space. Sort of the less pleasant, one of the less pleasant high-profile events of 2011. In this debate, I think sometimes it's lost a little bit that data breach notification is important. Protecting consumers' information is important. But I think it's also important to recognize that these are criminal acts that are causing these breaches. There is corporate responsibility to do the best job you can, both at protecting information and in rapidly, quickly notifying users if you've been compromised. But everyone agrees. I was a computer crime prosecutor. I mean, everyone agrees that if you do everything right, it doesn't mean that you can't prevent something wrong from happening. And so I think, a little bit just personally that we need to drop the romanticizing the notion of hacking in some quarters. It still persists a little bit, and look at this, problem holistically, and that there's a criminal element there too that needs to be addressed. And so there are a couple of different approaches in Congress. One sort of takes that view, and Senator Reid, as I read yesterday, is looking to try to introduce again soon a broad cybersecurity bill that addresses data breach notification, data security requirements, but also more broadly funding for law enforcement and government approach to the issue, critical infrastructure. The alternative are 6 or 7 bills that are focused much more narrowly on data breach. And I think the sense here, similar to privacy, is that these solutions will move forward, but there's still enough disagreement that in an election year it may be difficult to see anything emerge. On the state side, we're seeing more efforts aimed at cyberbullying. Again, not targeting the video game industry, but online services generally. These are more narrowly focused at the actual participants, but they affect the online industry as well. Registered sex offender registration statutes, we're seeing some efforts in states to put laws on the books in that regard. Switching gears from privacy to accessibility, the Federal Communications Commission is not a body that you would intuitively probably think would have a lot of interaction with the video game industry. There was some interesting discussion yesterday about our industry has not been a litigious one and not been a heavily regulated industry, as opposed to, you know, Ma Bell and the breakup and the baby bells and the sort of long history of heavy regulation in the telecom space. But the merging is happening, and we've found ourselves in front of the FCC this year, specifically in connection with the CCVA, which is an act that it reaches a number of different areas that require making different services accessible to the disabled community, things like closed captioning across different devices. Most specifically, for our industry, it reaches advanced communication services, so chat functionality. And it would require accessibility functionality to be built into that. And the FCC, both the law and the FCC implementing order allow for waivers for certain classes of equipment or services if the primary purpose of the equipment or service is not the offering of the communication services, but is something else. And so, intuitively, you can all probably grasp that in-game chat is a feature and a functionality of a number of different game platforms and game software. But we feel strongly that that's not the reason why people play games. It's certainly not the primary purpose. That the game is the draw. There are plenty of instant messenger services and other, on the Facebook platform you can chat just through Facebook if chat is your aim. And so we are planning to file. We filed a petition for a waiver. The FCC issued an order and basically reset the clock, and so now we'll be seeking another waiver there. Interesting things happening internationally as well. In Korea, a couple laws. One that imposes nighttime shutdown requirements. Directed mostly at MMOs, that they have to be turned off from midnight to 6 a.m. for minors. And that in combination with that, there are age verification and registration requirements imposed. Mobile games are exempted from that. Console games, by and large, to the extent you're not paying separately for the online component, are accepted. And there's a little bit of lack of clarity between the two laws on their reach to different types of PC games beyond the MMO. But to the extent this sort of regulation, Korea is a bit of a unique situation, but to the extent it took hold in other areas, that's something we're watching. Online games, obviously, many of them rely on subscription revenue, and there have different varieties of auto renewal clauses. A lot of states taking very different approaches to when these auto renewal clauses are enforceable. Some of them have laws that we think work well, and our state government affairs team is out there covering the playing field, trying to ensure that they're, what our industry always wants is uniformity, right? They don't want 38 different sets of laws that they have to figure out how to comply with and tie to different users. They'd like to know what's expected, and then we'll do it. So that's one of the things that we're working on. Taxation of game content is another. Again, whether digital downloads are taxed, in what instances they're taxed, the taxation of microtransactions, I think is a looming issue. We are at a period where state legislators are actively seeking revenue. So they are going to look for it wherever they can find it. And so I expect us to be pretty active on this front. Money laundering compliance is not something that's probably been at top of mind for video game companies, but the FinCEN and the Department of Treasury issued some rules last year that could potentially affect or have affected the video game industry, because they attached to reporting requirements for, it's for anti-money laundering purposes, but reporting requirements to prepaid access, and obviously gift cards and those sorts of things are a big part of how our industry does business. The last bullet there is the most significant, and something that we had at ESA and industry had filed on, seeking sort of a floor beneath which the trigger wasn't pulled for reporting requirements, and it's a $2,000 per day for closed-loop prepaid access, which, largely, at least today where we are, I think, largely insulates most current models. Another area, interagency working group is poised. They have been poised for quite a while, so it's there's been some pullback on this to issue guidelines. They would be voluntary guidelines for food marketing to children in a number of forums, including video games, in-game advertising. What we're hearing is that it originally was going to apply up to all minors. There may be some scaling back of that to sort of under 13s, that sort of thing. There are questions. Congress is there have been some questions about what this process is about. We had filed comments there. Obviously, the Brown case, again, makes it clear that whatever sorts of guidelines come out or rules develop in this space, that the video game should be, again, put on equal footing with other forms of entertainment that have advertising. Right of publicity, I just sort of spoke to a bit earlier, but we still see state legislatures. Most right of publicity statutes have carve-outs for expressive works, and they'll, to the extent they denominate what that means, they'll typically say film, television, literature, comic books, things like that. They don't. Some now say video games, thanks to our hard work. Most are silent on it. We are still seeing, even in the wake of Brown, states, largely led by the Sports Players Union, the NFLPA particularly, to ensure that video games are not listed and, in fact, are put in with some sort of lesser status, so only protected to the extent the Constitution would protect them. Sort of, again, disparate treatment. And so we think Brown offers a very strong rebuttal to those sorts of provisions, but it also shows that our work's not necessarily done. That is all. I think I've preserved a few minutes for questions, which I'm happy to take on anything I touched on or anything else. Yeah.
What are some solutions to piracy that you've mulled over?
That I've mulled over personally. So I think there, as I said, I think it has to. The solutions are, there's no one solution, right? And so it's a broad array. I mean, I think one of the things that's a little different about the video game industry is, a lot of the criticism that you hear of some other industries is that they're not rapidly changing their business models enough to address consumer demand. And I don't think that that's a fair critique. And I don't hear it levied against the video industry that much, and I don't think it would be a fair critique. So I think our industry is doing a great job of trying to figure out all the different ways to get content to users. So I think we're addressing some of that in that way. I do still believe, however, though, for AAA titles that cost $50, $60, $100 million to create, and a lot of blood, sweat, and tears and incredible talent, that those investments are worthy of protection. So I think we do have to have strong copyright protections. I think as we move into more and more of the content being in the cloud, I think that the DMCA's anti-circumvention provisions are critical because we have to be able to protect those game environments. I did work on these issues in private practice, so I've sort of got a lot of involvement in that. So I think sort of preserving the rights that are on the books, and then thinking about ways that we can meaningfully address the real problems with overseas sites where the function of the site really is to financially incentivize the distribution of clearly protectable copyrighted content. It seems like we ought to be able to find a way to do something about that again, in our industry, we're obviously very sensitive to doing that in a way that's balanced and that doesn't stop innovation, because we're innovating, and we don't want to see innovation stifle. Hmm? Yes.
Christian, thank you so much. Wonderful presentation. Learned so much from you today. Let's talk a bit about data security. You alluded to it, or no, you did not. You spoke directly to it and said that really it's a crime, and we should treat it as a crime, and there's no question about that. But do you see maybe some differences between cybercrime and regular crime in the sense that when we're dealing with data, some of these criminals are doing it for sport. Not a lot of people do street crime for sport. There's a big difference between robbing a bank or breaking and entering into a home. You can't break and enter into millions of homes at the same time. There has to be some process that you go through. Whereas when you deal with data security, when you deal with the internet and these things, it just seems to me that there are thresholds that are very, very different. Two things. One is the committing the crime. It seems that the barrier is much lower. Some actually do it for sport and nothing else. And then the other one is the result of the crime, if you will. That crime perpetuates over time, is very difficult to clean up, it affects millions, hundreds of thousands, thousands of people. And it's very, very different from going into my doctor's office, breaking and entering, going behind the counter, reaching and stealing, let's say, my medical document. That requires a lot of things, and it's so much easier at the end. And then if they steal one piece of paper, it's different than stealing something and then just distributing to the rest of the world. And then all the cleanup that has to take place. Can you speak to that in terms of the difficulties associated with crime, which we're used to? And I agree with you, cybercrime is crime, but is it a bit different?
Yeah, I mean, I think one of the things that's important is, there is some differentiation, right, between different types of cybercrime, and I think you can look at the consequences. I mean, when when anonymous, allegedly takes down the DOJ website and for an hour and a half, or the MPAA website for a couple of hours to protest the mega upload indictment. To the extent that happened, that's sort of cyber vandalism, right? It's making a point, and maybe we feel a little differently about that. When hackers infiltrate, an online gaming network and steal credit card information for users in a manner, and continue to assault the network in a way that requires that the network be taken offline. That's a very, very different sort of crime. And I do think that, I was at DOJ in 1999, 2000, and one of the big cases I worked on was the day that denial of service attacks took down eBay, Yahoo, sort of the pillars of the internet at that point. They were all down for 6 hours. And it was interesting because, obviously it was very important to me. I was leading the investigation and ended up with a 15-year-old in Canada who was the mastermind. But we probably feel pretty differently. We would wonder if something worse was afoot if that happened today. But the other argument is that physical stores, they close every night for several hours. They're not available for at least 6 hours every day. So a website being down is one thing. I think we've evolved from that time to now to where most people understand the difference between that and something that can have long-lasting ramifications. Some of these breaches are for sport or to prove it or a form of protest, but even when they are, there is often an underlying, very decidedly less romantic goal in mind, which is to quickly hash and distribute the stolen credit card numbers to a variety of networks where they are bought and sold and used quickly. And that, if anybody in here has ever had that happen to them, had their identity stolen, had their credit card used, even if ultimately it doesn't cost you anything out of pocket, it is an incredibly frustrating experience that jams you up for quite a period of time and sort of changes your sensibility about interacting and providing information, and that's not good for our industry or anything tied to the online industry. So I think, my point of view is that we want our industry to be a leader in safeguarding its customers' information and doing everything. And I think the year, I don't think anybody was not taking it seriously, but last year was certainly a wake-up call. But it's important to know that RSA was, the companies that provide the solutions that the rest of us rely upon were victims of hacks in 2011. So it was a pivotal year, and I think a wake-up call for everyone to sort of redouble efforts. But again, I just do think it's got to be part of the debate that these are criminal acts, and the corporate responsibility, class actions to sue victims of crime for where there's not sort of clear negligence involved in protecting the information, I think that's moving in the wrong direction.
So, but do you feel that law enforcement does treat these cyber crimes with severity? I mean, the average guy on the street, if you ask them, they'll tell you, if you steal $50 from 7-Eleven, you're going to do time. If you steal the credit cards of God knows what, they'll never find you. The sense?
No, I think, I think the commitment is there among law enforcement. It's a hard problem because you're not going to go kick down the door down the street of, nothing's happening in the same place. It's often collective activity creating the crime. Their social engineering phone calls are often behind these, great sophisticated cyber attacks. So there's probably some training, that can continue to be done there. But I think the law enforcement commitment is there, but it's an international problem that requires an incredible amount of coordination. The crimes are often complete by the time anyone figures out that they occurred. And you're trying to backtrack and figure out what happened. And then, we used to say, back when I was at the Justice Department, we were trying to get past the days where it required a quill pen, and a glorious piece of paper to send a request overseas that you got a response from 9 months later. That's the way international law enforcement coordination used to work. And there's a lot of work done. There are now really great 24/7 networks, and there is real-time response on an international level, but it's hard. I mean, I think that's the not pleasant but true answer. Yep.
This may be kind of a legally naive question because I don't have a background in law, but with this
that's good. So whatever I say, it'll be fine.
With this Brown decision defining games as an expressive medium alongside a novel or whatever, is that going to change the way gaming companies, whether they'll fall under patent law or copyright law? Because you wouldn't patent a novel. So if you could explain.
Yeah, no, I mean, so you patent inventions, right? And that can be business processes. You copyright the expression of an idea. It's not the idea itself. There's some protection for ideas, less protection for ideas than inventions or expression. I think there are some interesting ways it could play out in terms of not so much in the U.S., but there are different ways that different countries for things like taxation or tax exemption status classify works differently. So you might see at the margins some impact there, whether something is whether you classify it as software or as an audiovisual work. There are some implications there, but legally and it's sort of not in the IP area as much.
From where you've been talking about, but you have thought about, or the ESA have thought about trademark implications of user-generated content where often they're using what the content provider probably considers it's copyrighted and trademarks to be associated with the user-generated content.
Yeah, I mean, I've certainly thought about it, and I think, a lot of those issues are going to arise in very fact-specific contexts that may, in some cases, have one content owner against another. So in terms of a broad industry effort, there's some limitation there, but certainly something we think about and follow. And it's similar to the types of things that were discussed earlier this morning and yesterday morning too about trying to define where those lines blur. And I think largely there'll be two ways in which that debate develops. One will be what rules are in place for the particular game you're playing. Those rules may not be the same for all. There may be games. It may behoove one game publisher to really encourage the use of user-generated content in the game, to license back, to ask for a license to use the user-generated content in the game, but retain the rights with the user. There are others where the game environment may be such that you're allowed to generate some level of content, or your interactivity with the game will allow you to generate something, but it's very clear that the rights rest with the game publisher. And I think one of the things that's important, particularly for smaller developers as they emerge, is to think about those things on the front end to the extent you can. I mean, sometimes the games take a life of themselves. They go in a different direction. But to the extent you have spelled out clearly sort of the rights, the apportionment of rights and responsibilities, that's going to speak to it largely. I think that the second part is the technology itself. Again, what Richard talked about you can build into your game design some things that make it obvious sort of what's going to happen, because it happens as a matter of the game design. So I think those are probably the two ways that we'll see a consensus coalesce around how we treat the issues. Yeah.
What did you think about, going back to the whole data security brief, what did you think about Sony's amendment to their terms of service having players basically forego their right to have class actions to?
Oh, like the arbitration clause? Yeah, I mean, I think that, there's a Supreme Court case that came down that overruled a California case. There was a lot, and this isn't a Sony issue. This is an industry, not a video game industry issue. This is everyone who has a terms of use agreement with their consumers, online and offline issue. I could point you to countless law firm blogs. Maybe there are people in this room who have written blog posts to this effect, that advising in the wake of the California decision to tweak their terms of use, to be careful not to have a provision that would be struck down under that decision, and then advising after the Supreme Court decision that they might well want to go back and tweak their terms of service again, because it's very clear they have a contractual right to do that. And so I don't know that that's really, if you look at it broadly, a particularly controversial thing. I mean, I was not, the only class action work I did in my private practice days was defending them, so I tend to be not particularly a fan. We all are influenced by sort of where we come from of class action litigation. I think that, many would agree there's certainly not exclusively, but there's a lot of class action litigation that imposes incredible cost on business that doesn't necessarily end up flowing a lot of benefits back to the consumers who are purportedly represented by the class. That's my opinion. That's a personal opinion. Okay. Thank you all very much.